Corporate restructuring. And in corporate restructuring, we have terms that we will use that are not defined in the Companies Act. We talk of a merger and we talk of amalgamation. These are synonymous words that can be used in place of the other, and these are not defined in the Companies Act. But the provisions that relate to mergers are covered under Section 207 to 210 of the Companies Act. And any proposal of a merger begins with the process of due diligence. You must identify. You see, a merger is when you want to combine. You have seen a company A and company B. You want them to form company AB. So due diligence is a must. Inquiring, investigating, confirming that what is seen on the face of it is reality. It's not just, they're not just putting up a good show, but they're actually performing as per the expectations. So despite not having definitions in the Act, there are rules that will be followed when a merger or an amalgamation is done. And the provisions of the Act deals with the compromises or arrangements, and the court can sanction any matter. The court has that discretion that where a merger is ongoing, an issue is brought, they will look into the affairs. Were they done openly, or were they done in a way that sought to, again, cause harm to the shareholders, cause harm to the general public, future investors? What did your actions actually, what were the intentions behind your actions? And what did your actions bring out? So a merger, this is when two companies join together under the name of one of them, or as a new company formed for that purpose. And this only takes place when there's an agreement between directors, company A and company B, and the directors agree, we can do better together instead of being apart. So the companies will either take on a new name, or they will continue operating under the old name, one of the old names. This is what we are saying. Company A and company B, they may be merged and operate under company A, or they may be merged and become AB and continue to work. A takeover, on the other hand, is when one company, A, and this is the target company. You look at company B and you realize company B is struggling. And you remember, a takeover may be hostile or it may be agreeable. Where we are saying it's agreeable is when company A approaches company B with a view of solving its issues and will adopt the model that is currently being done. And it may even allow company B to continue trading under its name with the changes that will be done. A hostile one is where it's a takeover, literally. Company A is there, company B is struggling. They do not give company B a chance to, they will not give you a chance to reorganize your books or to seek funds to stand up. They simply come and take over and impose their will, that this is how we do our business and this is how you also do your business. You don't have a chance and you don't have a choice. We will take over because we have the resources. We are the bigger company in terms of assets, in terms of in terms of know-how. We have the capacity, we have the technical skills to be able to take over your company. And when we think of takeovers, there's Brookside that took over the operations of other smaller dairies, and they enabled them to continue operating under their own names, such that on the face of it, you can find products from different, they will continue trading under their names. They did not take over and put it all as Brookside Dairies. But the essence of control is necessary. For a takeover to be effective, they will control the operations of that company, in as much as they will not rebrand them all to be that Brookside. They will have control. They will have the powers to hire and fire. They will have the powers control the distribution. They will have the power to check on new entrants, on where you want to spread your distribution and such. And at times, takeover bids may be contested by the directors. You see, for mergers, it's friendly. The board of directors have agreed. For takeovers, especially the hostile takeovers, the board of directors may resent and may reject. And they may want to reorganize in their own way without involving other companies.